Welcome to the DisabiliTEA, a podcast where we have candid discussions about all things related to disability. Short-term, long-term, financial claims, impact on other areas of life, causes in the workplace, and more. With your host, attorney Anjel Burgess. You can find this show at www.disabilityhelpline.com and on YouTube, Facebook, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more. Now here's the host of the DisabiliTEA, Anjel Burgess.
Good afternoon, everyone, and welcome to the DisabiliTEA. Today, we are really excited to have with us attorney Shannon Worthy, and she is from Stanton Worthy. She is going to talk with us all about bankruptcy. Welcome, Shannon.
Hi, Anjel. How are you?
I am great. I am excited to learn about bankruptcy because I know next to nothing about it. So thank you so much for coming on.
Of course. Thank you for having me.
So I want to just jump right in, Shannon. And first, if you just tell everyone a little bit about yourself and your practice.
Okay. So I'm Shannon Worthy. I am a co-owner of Stanton Worthy. We are located in the Metro Atlanta area, specifically in the Old Fourth Ward, not too far from Ponce City Market. We've been practicing consumer bankruptcy for about maybe 8 years or so now. And prior to beginning Stanton Worthy, I used to manage the Cochran firm. The Cochran firm's bankruptcy division. I still own a part of that, and we still have clients that are a part of the Cochran firm bankruptcy division. So out of my business, we kind of own and operate two businesses. So there's Stanton Worthy, and then we also have the Cochran firm's bankruptcy division as well. We merged the two, and they are housed out of our office here in Midtown Atlanta. Again, it's consumer bankruptcy where we assist individuals, specifically who we call the debtor being just most consumers, the ordinary, everyday, middle class person. The Cochran firm, when we were running that full time, that's probably maybe, I'd say 12 to 15 years in the making. And then Stanton Worthy is about 8 years in the making. So
excellent.
Yeah.
So a lot of history and experience with bankruptcy.
Yeah. I can't believe it's over a decade at this point. I remember entering law school. So
time flies when you're having fun.
Yes.
So I want to ask you, just kind of backing things up to just very basic understanding, because this is going to help me to understand bankruptcy a little bit more. But first, what is bankruptcy?
Okay. So bankruptcy is the opportunity to potentially rid yourself of debt or restructure your debt. And the opportunity is afforded to us by the federal government. So when you file bankruptcy, it is a federal case.
Okay.
And it allows individuals to restructure debt such as mortgages, car loans, credit cards, or to completely wipe it out, or as we say under the law, discharge it. And to discharge it, it means to just completely get rid of it, wipe it out, and give you that fresh start, depending on which chapter you file.
Okay. And you mentioned the phrase consumer bankruptcy. So can you tell us a little bit more about what that means?
Yeah, so consumer bankruptcy focuses on the consumer or the individual. There are business bankruptcies that will focus on actual entities, corporations, nonprofits, churches, various entities that aren't human, I should say. So the actual individual, the debtor being you, me, your aunt, your uncle, your mama, your daddy, your child, the actual consumer, whoever can obtain debt in their name or obtain ownership of items in their name and actually flesh and blood. So the consumer, I should say.
Okay. And why would a consumer want to file for bankruptcy? Like, what are the circumstances under which? that would happen?
Yeah, that's a kind of a loaded question, but there are maybe a top 3, top 5 reasons.
Okay.
The number one reason, especially in the United States, it would be because of medical debt. Most individuals that file bankruptcy, a Chapter 7 or Chapter 13, it is because of medical debt. As you all know, to have a baby in the United States is extremely expensive. To get sick in the United States is extremely expensive. And this is not just because you do not have insurance. Most of my clients who are filing have really good insurance, you know? So I would say medical debt is the number one reason. The next reason would probably be a failed business. A lot of entrepreneurs file for bankruptcy. I think the saying is within the first 5 years, most businesses fail. And it isn't because the consumer didn't work hard. Stuff happens in a business, and a lot of stuff you can't account for in many instances. And it's your first rodeo. So that would probably be the second major reason, a failed business. The third would probably be because of divorce. Most of my clients are filing because there's been, and I guess that's two-sided, I would say, divorce and a change in income. So if you're getting a divorce, you're going from that two-person household or two-person income household to now it's down to one. And that could be a change in circumstance, not just due to divorce, but so a change in income, but in many instances because of a divorce. And with that drastic change, that typically will prompt individuals to have to file because they no longer have that residual income, that extra income, that income there to help really support themselves and maybe even dependents.
Okay.
And it's two households that you're taking care of as opposed to just one. So those I would probably say those are maybe the top 3 reasons that individuals will file.
Now, in telling us the top 3 reasons, one of the terms that I heard you mention, you said Chapter 7 or Chapter 13.
Yeah.
So can you tell us what those are and what the difference is?
Yeah. So a Chapter 7 is when an individual wants to completely get that fresh start and just discharge or wipe out all of their debt. They're okay with walking away from a lot of things. They're okay with doing that. And there are qualifiers for the Chapter 7. The main 3 are that you have not filed a Chapter 7 within the past 8 years.
Okay.
The other is that you do not have any equity in any real or personal property. Equity being if you have a home and you have a mortgage, there's no equity in the home, or you don't have any equity in the home or in the vehicle. That could also be a bank account, but no equity in anything that could be liquidated to sell and then pay off your debts.
Okay.
And then the other is that you're under the median. So here in Georgia and in every state in the United States, there's a median income. So depending on your household size, you have to be at or under the median income. So for a household of 1, I think the median income may be about $62,000. Household of 2, it might be closer to 70, 71. 3, and it'll keep going up as your household gets larger. So you have to be under the median, haven't filed bankruptcy within the past 8 years or Chapter 7 for that, and then no equity in any real or personal property. And for a Chapter 13, this is usually for individuals not necessarily needing that fresh start, but they want to restructure their debt and make payments more affordable, right? So they have a mortgage and the mortgage has become too cumbersome and they've missed payments. That could be anywhere from 2 payments to 25 payments. And that can be for a number of reasons. It could be, hey, you were out of work, you were maintaining, you took all of your money out of your 401k and you maintained for a year, but now a year has passed. You thought you were going to go back to work, but you haven't yet. So now you're like, okay, I don't want to lose my home, so I need to figure out something, right?
Right.
So you can file a Chapter 13 to help restructure that debt. Will help restructure the payments associated with your mortgage. We can do the same thing with a vehicle, tax debt, similar, same thing. So these are usually for individuals who have assets or items that they want to keep. They don't want to walk away from it. They want to save it. They want to stay in their home. They want to keep their vehicle. They want to get that tax debt down, and they want to save what they worked so hard for. And the Chapter 13 will restructure your debt. There are qualifiers for it, but most individuals qualify for a Chapter 13 as long as you have some sort of income.
Okay.
It could be wages, it could be 1099 income, it could be fixed income such as Social Security, it could be an annuity. As long as you have some sort of income coming in that proves that you are able to maintain a monthly payment to help pay off your debt.
So with the Chapter 13 and kind of the restructuring, are you in essence just like extending the life of the loan when they're restructuring the payments? Or, I mean, is there any reduction in what you owe as a result of filing?
Yeah, in some instances. So there isn't a like an extension in payments.
Okay.
In many instances, the reason why an individual would file a Chapter 13, which I would call like a complete consolidation of all of your debt, the benefits of it are in many instances, we're able to lower the interest rates associated with items. Sometimes you're just paying the principal as opposed to interest.
Okay.
In other instances, I would say if you're facing a foreclosure. So my clients, if they come to me and they say, hey, I have a foreclosure, it's pending on the first Tuesday of this month. In Georgia, foreclosures take place on the first Tuesday of every single month, and they want to stop it. They are 5 months behind on their mortgage. Filing a Chapter 13 bankruptcy would immediately stop the foreclosure. And we would take the amount that they are behind and put it into what we call a planned payment. And this planned payment would take those payments and stretch it across 5 years. So if you owe $10,000 in mortgage arrears or back payments, we would take those payments, stretch it across 60 months, which is equivalent to 5 years, and you would make those payments directly to a trustee each month. And you would be deemed current. Once you file, you would be deemed current on your mortgage. You would have to maintain your ongoing mortgage, but you would have this small payment each month paying back the arrears. But this doesn't stop you from potentially like seeking a loan modification with your mortgage company. I've found that in many instances, it actually pushes or provokes the mortgage companies to work with you on a loan modification because they don't want to receive their money from the court. They would rather receive it from you directly. So once they see that you filed bankruptcy, they're usually like, let's get this person into a loan modification so that we can move forward and get our payments from them directly as opposed to from the federal government.
Okay. So, I think about as you're explaining it, that obviously I have a lot of clients who they've gone out of work, right? Because they have a condition or an illness or whatever it may be. There is some physical or mental health reason that has interfered with their ability to work. So now most of them will have no income any longer. They've applied for disability. They're trying to get help, but they're finding themselves in situations where I can't pay my mortgage.
Yeah.
If they have a spouse or a partner or someone helping them out, then maybe they have some temporary kind of financial support. But generally speaking, most are just not able to make payments on things. Or if they are, they've got health insurance issues where their copays and premiums and all of these things are just financially wiping them out. So it sounds like from what you're saying, if someone finds themselves in that situation, there could be some options either through Chapter 7 if they meet the requirements, which sound much more strict than Chapter 13.
Yeah, absolutely. So I would say I have quite a few clients that are on a fixed income that receive Social Security or waiting to receive Social Security disability or Social Security as it pertains to retirement, right? So I have a lot of clients that meet that criteria. I will say most of them are filing, the ones who have not yet been approved for Social Security disability, they're usually filing the Chapter 7. And the reason why they're filing the Chapter 7 is because I can't show that they can support a monthly payment to repay their debt. With that being said, a lot of them, uh, they don't necessarily own homes. So they're renting, it won't affect their rent, but it does alleviate the credit card debt, the personal loans. If they no longer want their vehicle in the Chapter 7, which here in Georgia, we really do need vehicles. But if you no longer want your vehicle, you can surrender it in a Chapter 7 and you won't be responsible for the debt associated with it. So it provides them with that fresh start so that when they are approved for their Social Security disability, they aren't repaying a whole bunch of people or anyone at all. They can utilize that money to help really sustain what they need, and that's a home and maybe even getting a new vehicle and things like that. So I would say for those individuals waiting to be approved for Social Security disability, the Chapter 7 is probably the best way to go.
Okay.
If they have already been approved for it and they have a mortgage and they're just trying to maintain what they have going on, a Chapter 13 is likely the way to go because we can show that they have the fixed income and can maintain their payments each month. But if they call me, I can give them the best advice, and we can go from there.
Well, and speaking of calling you, how does it work with bankruptcy, whether it's Chapter 7 or 13, and attorneys? Is this, do you have to have an attorney to file for bankruptcy? Is it recommended?
Yeah, it's highly recommended. It's it's extremely hard, even for attorneys. So judges will tell individuals who are pro se,
Mhm.
you should get an attorney. You don't
Okay.
have to, but you should really get an attorney because the likelihood of your case being successful, even with an attorney, can sometimes be slim to none.
Okay.
So you need an attorney. I think maybe Chapter 13. I wish I had the statistics on this. I just recently looked at an article on it, but I would say less than half of all Chapter 13s get confirmed. And that's the posture that we want them to be in. If your case is confirmed, that means the judge has provided his or her stamp of approval on it, as well as the trustee. And all parties have come together and said, okay, this is going to work. This is what we agree on. So I would
Okay.
say less than half of cases, even with attorneys, get
Wow.
confirmed. So an attorney, you certainly need an attorney to kind of navigate it. It seems simple, but when you have to start speaking with your creditors and those attorneys that are representing financial institutions such as Bank of America and Chase and Wells Fargo and Santander, you want to have counsel if your bank has counsel.
Absolutely.
That's how I sell it to my clients. Like, why do you think you can just go up against the attorney for JP Morgan and Chase?
Right.
Why would you want to do that? Even though the paperwork seems simple and you can fill it out, there are fillable forms. It doesn't mean that you should. It doesn't mean that you should.
Sure. Are there any kind of red flags or things that you wish prospective clients knew before they came to you?
Yeah. I do like the clients who are kind of like a blank slate. They didn't do a lot of research. I would prefer to educate them as opposed to my clients who go to Google University.
Right.
I don't like competing with Google because for every circumstance that you put into Google, they're going to come up with an answer that could potentially work. And that may not be the case. So I would say you want to educate yourself, but not to the point where you think you're the attorney. But also, I would want my clients to know in many instances, I would probably say 95% of the time, you get to keep what you have, your assets. You're not getting rid of your home. You're not getting rid of your vehicle. You are usually able to keep those items. And I would stress just being very transparent with the attorney that you hire, and overshare as opposed to undersharing. Because in a bankruptcy, not sharing what you have going on financially and the assets that you have, whether it be the amount of money that's in your bank account, if you have a life insurance policy, if you are the beneficiary to a trust, if you own a pair of Gucci socks, some Gucci flatware, whatever, overshare so that I can protect it. When you have assets, it's my job to protect what you have. The state of Georgia, the federal government allows us exemptions so that we can protect what you have and you don't have to sell it or liquidate it. But it becomes an issue when you don't share it or disclose it, I should say. When you don't disclose it, it then starts to look like, now, is this fraud? Like,
Right.
That's what it's, and then that's when I'm sorry, I'm gonna have to throw you under the bus because Shannon Worthy did not know. I did not know about this mink coat or this $10,000 in this obscure account, you know? So in most instances, I can exempt the full $10,000 that you have. Or if you have a shared bank account with you and your child, I can say, oh, this is, you know, my client is not the owner of this account. My client is the authorized user on this account. So that is not my client's asset because they're just a user. They're not an owner of the account. So I think disclosing it allow me to do my job and to protect you. So the moment you take that away from me, I can't properly prosecute the case. So I would say just be more of an open book, overshare with me, and allow me to protect you and help you.
Excellent. How long does this process take on average?
A Chapter 7 on average takes anywhere from a Chapter 7, what we call a Chapter 7 no assets, takes anywhere from 4 to 5 months.
Okay.
So out of it within 4 to 5 months. So if you file right now, you'll be out of it in time for the holidays. That's what I've been telling my clients lately. A Chapter 13 typically takes 3 to 6 years. So 36 months to 60, 3 to 5 years. I'm sorry, 3 to 5 years. And that is because you are paying off items. So in a Chapter 13, you are paying off your vehicle.
Okay.
So it's literally like the same amount of time. If you have a $25,000 vehicle, it's probably going to take you 5 to 7 years to pay off without the bankruptcy. Inside the bankruptcy, we're protecting it. It's not subjected to repossession, and we're paying it off. After it's over, you still get your title on the car, but you're paying it off in the bankruptcy, and you may be paying some other items as well, or maybe not. It just depends. But there are some ancillary things that can happen in a Chapter 7. While the average time may be 4 to 5 months, if we have some hiccups in the case, if we have liquidation issues, or not even issues, if we have liquidation at play, that could take a few years as well. So if you say, hey, I do have a home, I know there's equity in the home, I'm okay with walking away from my home, the trustee and the judge will then say, okay, well, let's put the house on the market, see how much money we can get, sell the home. And once we have the proceeds, let's pay off your creditors. And if there's anything remaining, you'll get the remaining amount. If there's nothing remaining, you'll get a discharge. So everything else that we couldn't pay off, it'll get wiped out. So that takes some time to do.
Okay. What about downsides? Are there any downsides to filing for bankruptcy?
I would say in a Chapter 7, the downside of filing a Chapter 7 would be a hit to your credit, both of them. So it's going to show up on your credit report that you have filed a bankruptcy. A Chapter 7 shows that you've walked away from everything. So your credit score will probably take more of a hit, right? The Chapter 13, not so much. It's still going to show up on your credit report, but it's going to show that you've repaid all or some of your creditors.
Okay.
So I've actually seen clients in Chapter 7. They're like, my credit score increased. And I'm like, yeah, because you're repaying everyone. It's just a consolidation where you have the protection under the law. So I would say that would be it. And then also when you're in a Chapter 13, because you're in it for that 3 to 5 year period of time, you have to consider the court like a babysitter. Anything that you want to do financially, you have to get it approved.
Okay.
So you can't just say, oh, I'm kind of tired of this car, I'm ready to go trade it in. You have to get permission first, which means I have to file a motion. And I will not be putting in that motion that you're tired of the car. I need to say something more in the vein of legal ease. This car is now inoperable. It was stolen, repossessed, or not repossessed, but it was stolen, car accident, something.
Okay.
And I would petition the court and ask them if it's okay for you to incur new debt and purchase a new vehicle. And the same thing with the home. If it makes sense to the court, if you are paying $2,400 in rent and you say, if I get approved for this loan, I'll be paying $1,200 in mortgage, the court is going to say that, okay, I approve that. Go ahead and get that $1,200 mortgage because that means more money towards your creditors.
Right.
More disposable income.
Okay.
So I would say consider it a babysitter for the length of time that you are in the bankruptcy.
Okay. And I know that earlier you had mentioned business bankruptcy. So I just want to touch on that. What circumstances would lead a business to file for bankruptcy?
So quite a few. If it's not maintaining, I think a couple of things for me. If it's not able to maintain like payroll for its employees.
Okay.
If the business is not generating like the same amount of income, if the business is constantly operating in the red, if the creditors for the business are threatening to garnish business accounts or levy accounts. If the business had to pivot and you're like, okay, this business doesn't even make sense anymore. I think I need to dissolve it anyway, but the business has debt.
Okay.
You can do like a business Chapter 7 where it will be administratively dissolved at the end of the Chapter 7.
Okay.
And you don't have to, I think a lot of times my clients, they'll think like, well, if the business files bankruptcy, I won't be able to create another business. That's not true. Like your future business hasn't filed,
Right.
so your business can file. And in some instances, your business can file like a Chapter 11 and restructure the debt as well, which is similar to a Chapter 13. It's just restructuring the debt associated with the business. Instead of you paying $20,000 per month to your creditors, whether it's the credit card holders or a lease that you may have for machinery or equipment, we enter into agreements with those particular creditors and say, this is what my client can do per month based off of the income that's coming in.
Okay.
So I guess those are a few reasons why businesses may file.
Okay. Wow, so much good information about bankruptcy. I'm learning so much. I wanted to just kind of, in wrapping up, go back to the consumer side.
Mm-hmm.
And if you could just give our listeners and viewers maybe some examples of scenarios that would trigger them to think, oh, you know what? Maybe I should call Shannon and talk with her about me potentially filing for bankruptcy. Like, what are some things or situations that people may be in where they should know that they should talk with you about potentially filing for bankruptcy to help their situation?
Okay, yeah, there's a few. So garnishments. A lot of people here in Georgia, I guess most residents of Georgia don't realize that you can be garnished. And garnishments basically mean that your wages can be reduced based on a debt that you owe. So they'll send a wage garnishment to your employer, and your employer will have to withhold a certain amount. Typically in Georgia, it's about 25% of your wages. And they'll continue to withhold that until the debt is paid in full. A lot of people don't know that garnishments can even be stopped, but a Chapter 7 or a Chapter 13 can completely eliminate it or wipe it out. So I would say garnishment, a wage garnishment specifically, and also a bank garnishment. A lot of my clients are surprised when they wake up in the morning, they check their bank account, or they go to get gas or groceries, and their card isn't working. They're like, "It's money in here." You check your account, there's a freeze on your account or a levy of sorts. This usually takes place if there is a creditor that you may have owed, and they have a judgment against you. They were successful with obtaining a judgment against you, and now they have a garnishment against you. So bankruptcies can help with that. Also evictions. If you are facing an eviction and your lease is not yet up. So for those individuals who are doing month-to-month leases, bankruptcy won't help. But if you have some more time on your lease, 3 months, 7 months, a year, 2 years, a bankruptcy can stop the eviction. So typically the game plan is just to buy you some time. So if you file a Chapter 7 or a 13, I tell my clients it'll probably buy you about maybe 90 days. That 90 days is enough time for you to potentially get the money up needed to become current on your lease. So it'll stop eviction. It will also stop foreclosures as well. We've discussed that. Car repossessions. There's a little tricky part about car repossessions. If the car has not yet been repossessed and it's about to be, you can file to stop the impending repossession. And then also, if it has been repossessed, we have 10 days, we being my law firm, any lawyers in the state of Georgia, we have 10 days from the date that it was taken to pick the vehicle back up after you file bankruptcy. So if your car was repossessed today, you have 10 days from today to give me a call and to have me prepare and file your case. So it has to be done within that time frame. And they don't have the option of holding onto your car. They have to give it back once the bankruptcy is filed. So it's not an option. The only time that a car creditor does not have to give the car back is if it's a title loan. And this is recent litigation with title loans. Previously, they did have to give it back. As of now, they don't have to. But I will say, even if a title loan company has repossessed your vehicle or is about to repossess it, I would say still give me a call. And we have a good rapport with a lot of the title financers. So we may be able to just get it back, and it would be under certain guidelines, I will say.
Okay.
So I think those would probably be the main garnishments, foreclosures, evictions, repossessions. Those are like the hot ticket items that I think people should know about.
Okay, that's fantastic. People going through those situations, I think, in probably most cases, don't realize that there may be another alternative out there. So the fact that you have, provided us with so much really great information about bankruptcy, it's definitely something that I want to be sure to share with my clients so that they know that, hey, there may be something. I know you feel like there's nothing that can be done, but there may be something that can be done. And certainly from what I've learned from you today, I mean, maybe that can help you keep what you have, which, is, for most people, it's probably hard to imagine given, the situation. So thank you so much for sharing information with us today. How can people get in touch with you?
Oh, yeah. So you can contact our office, 404-800-6415, and our legal assistant will answer right away. And in some instances, myself or my business partner, Nicole, will answer right away as well. That is the quickest way to reach us. In addition to, I guess, social media, all of our handles is that what you call it? Is Stanton and Worthy. So STANTON, the word and Worthy, WORTHY. So that's on Facebook, Twitter, Instagram, TikTok. Everything is Stanton and Worthy. And you can also Google us. If you decide to Google us, you can, I know on our website, you can send a message to a portal and it actually comes directly to me. So in a lot of instances, I'm the one that's responding to you. I don't know if I should have said that because
Too late
a lot of instances, I'm the one that's responding to you, but I would say the best way would probably be just to call in and schedule a consultation. That's the quickest way to get in touch with us.
Okay, perfect. Well, again, thank you so much, Shannon Worthy, for coming and sharing your knowledge on bankruptcy. I know that it will be really helpful to our viewers and listeners. So thank you again.
Thank you for having me.
And this has been another episode of the DisabiliTEA. We hope that you enjoyed it and found it to be informative. And we are looking forward to talking with you next time.
You've been listening to the DisabiliTEA with Anjel Burgess. Thank you for your positive reviews, comments, and sharing the show with others. You can catch prior episodes at www.disabilityhelpline.com and on YouTube, Facebook, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more.